Scrounging forward.
All rise. First District Court of Appeals now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. Welcome to the First District Court of Appeal. We only have two cases on the docket this morning. I want to thank counsel for their ability to move up in the batting order, and you may proceed when ready.
Your Honors, may it please the Court? My name is Charles Tobin, Your Honors. Along with Deanna Schulman at counsel table, we represent Cable News Network, Inc. in this interlocutory appeal of an order from the trial court granting plaintiff leave to amend to state a claim for punitive damages. Your Honors, I've asked to reserve 3 minutes for rebuttal time when I conclude my opening remarks.
Mr. Tobin, could you move the mic just a little closer to you?
Certainly, Your Honor. Is that better?
Yes.
Okay. Thank you, Your Honor. Your Honor, plaintiff sued CNN for defamation concerning news coverage about profiteering in the chaotic days after the United States government withdrew their troops from Afghanistan. The record before this court shows that CNN aired these newsworthy stories after more than 2 weeks reviewing information from sources, including social media posts by Mr. Young, where he was flippant, evasive when people asked him about his pricing model. After 8 days of direct, evasive communications with Mr. Young, where CNN asked him about his pricing model, and he would not respond in any substance.
Well, it seems to me that with regard to the allegations that CNN said Mr. Young's prices were too high, that's kind of a subjective thing, right? You know, whether something costs too much seems like mostly opinion, right?
It is an opinion, Your Honor.
Okay.
An opinion is not actionable.
So the thing in this particular case that does seem a little more actionable was the fact that, you know, when they were talking about Mr. Young, they had his picture on the thing, and there was a chyron that says he was involved in a black market. And, you know, I've looked in a couple of dictionaries, 3 or 4, and the first definition for black market in all the dictionaries is criminal activity. And, you know, if you're accusing someone of criminal activity and they're not involved in a crime, that's that's usually defamation per se, correct?
Under the law where we would be looking at the defamatory meaning, perhaps it would be. Here we're on a question of actual malice, express malice, and outrageous conduct measured by objective standards. Under that criteria, Your Honor, regardless of what the meaning may be in the dictionary, which is an objective definition, what plaintiff needed to show is that subjectively CNN intended that meaning. Otherwise, there is no facts in the record to give rise to a reasonable jury question about actual malice.
Tell me how the triad works.
The triad, Your Honor, is a group of 3 different departments at CNN. It's the Standards and Practices Department, it's the Legal Department, and it's the Editorial Department. They come together and
so these are lawyers and professional writers that you know, are used to dealing with words and have dictionaries and know how precise what words mean?
One would presume, Your Honor, that they're educated people, that they've been in the business for a while, but, Your Honor, there is nothing in the record discussing the word blackmail at all among any of the CNN journalists.
Yeah.
And it is plaintiff's burden.
Well, black market is the word that was used in the Chiron, right?
Actually, Your Honor, the words used in the Chiron and said by Jake Tapper when he introduced the story was Afghans trying to get out of the country face a black market full of promises, demands of exorbitant fees, and no guarantees of safety or success. And so, in context, we maintain that it is clear on the face what CNN meant by black market, which is defined within the phrase itself. Market full of promises, demands of exorbitant fees, and no guarantees of safety of success. And there is no dispute, there is no evidence in the record that CNN, for example, knew that promises were being fulfilled or that there was a demand, there was not a demand for exorbitant fees. We just discussed that. That's an opinion, Your Honor. No guarantee of safety or success. The issue under
I hate to keep harping on this, but none of those things describe what could be commonly referred to as black market. I see Judge Roberts' point that black market clearly implies, dictionary definition or otherwise, an illegal exchange of goods.
Your Honor,
that has nothing to do with those other descriptions in the Chiron.
If it was a poor choice of words, Your Honor, and at best we argue that it was at best a poor choice of words, Your Honor, that may have impact on the rest of this case below under negligent standard actual malice, I mean, whatever standard the trial judge decides to apply. Here, in the punitive damages context, the burden was the plaintiffs in the court below to show that that is the meaning that they intended. It is not implied, it is not assumed by the court, it is based on record evidence under 768.72 of the intention for that meaning.
So what are we to make of the internal emails that were brought into the record where they called Mr. Young a shitbag? They said that they were going to nail this Zachary Young ever. Said he had a punchable face, said he was an asshole, and said it was his funeral, bucko. What do we make of those?
Your Honor,
is that at least some evidence of malice?
It's actually the opposite, Your Honor. It's evidence that the CNN journalists, as they were taking information in, as information was coming in from different sources, sincerely believed that Mr. Young was engaging in exploitive and shady practices. So, for example, at Appendix 408 to 413, in October 17 to 26, almost a month before this story ran, Jill Kornetsky, with whom CNN had already been corresponding, she was another person who was trying to help people through NGOs get out of Afghanistan. She showed CNN Mr. Young's responses to her questions. She said to him, "Tell me about this pricing model where you're charging $75,000 per carload, $14,500 per person. Tell me about your pricing model." He responded, "I don't have to defend our model to some spiteful bitch on LinkedIn. We waste someone else's time." He had a similar response to someone named David Lerner, who Ms. Kornetsky forwarded that exchange to CNN, to Mr. Marquardt, in which Mr. Lerner asked him $75,000 per carload, which is what Mr. Young quoted him, just for transportation? Mr. Young responded, "Just for transportation? You can't be serious. Good luck, David. Have them run for the board themselves and see how far they get." And on October 29, CNN saw an email as well from an Afghan, who Mr. Young quoted a price of $14,500 directly when the man said, "I have no corporate sponsorship." So we know that in the October 17 to 29 timeframe, CNN was receiving all of this information that showed Mr. Young was, at best, snarky, at worst, cruel to people.
Let me make sure I understand something. That last exchange with the Afghan citizen, that shows you that Mr. Young was dealing directly with Afghans. Even somebody specifically asks him, "Can I just pay you myself?" And he says, yes.
He says 14,500
Right.
was his answer. That's at
But
8334.
does that demonstrate that he's actually working directly with Afghans without a sponsor?
I would say a fair reading of that document is that he was quoting a price directly to an Afghan. CNN did not report on that, and I would ask the court to note that even though CNN had that particular email, this goes to actual malice, CNN refrained from reporting that information and went with Mr. Young's interpretation, which was sponsors only. They reported that 3 times in the Jake Tapper, in the segment run on Jake Tapper's show. They didn't report, and they reported it in the text article very prominently, that Mr. Young asked for sponsorship. And so, Your Honor, to get back to Judge Roberts' question, so by the time November 1 comes along, which is at A121, we've seen the text at 332, A332, A334, A138, and A408 through 13, in which Mr. Young engaged with people in a flippant manner who were trying to find help. And at that point, when Mr. Marquardt texted his coworker and said, "We're going to nail this Zachary Young M fucker," and then noted that he called Ms. Kornetsky a spiteful bitch. Our answer to Your Honor's question is that the pejorative terms, the curses that CNN used, showed that by the time they were receiving this information—
Well, whether Mr. Young had malice towards CNN is not of legal import here. The issue is whether CNN had malice towards Mr. Young.
But what I'm talking about is Mr. Young's language and Mr. Young's attitude formed the impression in CNN that he was a profiteer, that he was doing—
So your argument is his attitude led to the contentious things that were said about each other?
Absolutely,
Okay.
and that's the only thing that the record shows. After all, Mr. Young decided to move for punitive damages before any deposition testimony. So all this court has is the cold record. And in fact, Ms. Shulman urged the trial court to wait on the ruling until there was more evidence in the record. The trial court declined, and here we are. Your Honors, based on the cold record
So
that we have—
let's go back to what the standard is in 768.72. In subparagraph 1, it says, "In any civil action, no claim for punitive damages shall be permitted." So basically, the trial judge has to sit as a gatekeeper and have an evidentiary hearing unless there is a reasonable showing by evidence in the record or preferred by the claimant which would provide a reasonable basis for recovery of such damages. So what do you think that standard means, and why do you think that Mr. Young did not provide a reasonable showing by evidence?
Reasonable showing by evidence means that Mr. Young had to show 3 things to prevail in a case by a news media defendant about a matter of public concern: actual malice, express malice, both subjective standards, his burden to show, and then objectively that the conduct was so outrageous it's the worst of the worst conduct that a Florida society should not tolerate. That was Mr. Young's burden under the reasonable probability showing. If he could not show that evidence, and he did not, then he has no reasonable probability, no reasonable basis to ask a reasonable jury to find for punitive damages under the applicable standard in Florida. And so, Your Honor, as to actual malice, we've had the discussion. As to express malice, Mr. Young did not show that the primary motive for CNN in reporting on this story— after all, it was a 5-minute story, 2 minutes of which were about Mr. Young, and there was a lot of other information in there in a time frame when a lot of Americans—
But there were no other individuals that were highlighted as providing these overpriced black market activities.
That's correct, Your Honor. I merely pointed out to discuss what the record reflects as to CNN's motive, and it does not reflect a primary motive to do this story, to call Mr. Young anything other than somebody engaged in activities in a chaotic environment in Afghanistan, which was a matter not only of public interest, but the U.S. government's interest, the non-governmental organization's interest, and the interest of all Americans who were trying to sort out the U.S. government's conduct in withdrawing the troops from Afghanistan. And so, Your Honor, those were the three standards that Mr. Young had to meet. He did not meet actual malice. As we've discussed, if anything, the evidence shows CNN sincerely believed what it was reporting. He did not show that it was the primary motive of CNN to get him, which is what the case law strictly requires. And I'll be happy to discuss outrage if I have an opportunity when I come back for rebuttal.
All right. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court. My name is Val Friedman, and I represent plaintiff Mr. Young in this appeal. Your Honors, Mr. Young was a U.S. Navy veteran and a former U.S. government operative that worked for the United States abroad for many, many years. When he retired, he went to the private practice, began doing security consulting until in 2021, the U.S. government pulled out of Afghanistan and people started needing evacuations. Mr. Young was able to leverage his network of people and experience, very unique experience, to help successfully evacuate 24 children and women from Afghanistan on behalf of major corporations like Bloomberg, Audible, subsidiary of
So where do
Amazon.
we have that as part of the record? Do we have evidence of that?
That's all. Do you have evidence of that? This is in the amended complaint. I don't really believe it's disputed, but it's not necessary for my argument. It's just a bit of background. I'm happy
Okay.
to move on if that's helpful. CNN finds out about Mr. Young's work. It's not in dispute that he was evacuating people out of Afghanistan, and they set out on a path to take him down, or to quote the words of Alexander Marquardt, the main reporter on the case, to, quote, nail that Zachary Young MFer. And so CNN puts together what their own breaking news editor, Megan Trimble, calls...
Well, I mean, yeah, don't you agree that whether Mr. Young's prices were reasonable under the circumstances is kind of just a matter of opinion?
I don't think the reasonableness of his prices are being sued over. I think there are two bases that are the general, that are the bases for the defamation lawsuit. The first is, as the court has noted, as Judge Roberts, as you noted, is the black market definition. And Judge, I would add that the black market has one definition in every dictionary we've, not just the first, but one in every dictionary we've looked at. And CNN has failed to put forward any dictionary with an alternative definition. It means illegal activity. Full stop. And that's what the case law that we've quoted to the court as well treats it, illegal activity. So that's one basis. The second basis isn't about the amount of money he was charging. It's that he charged...
But do we need to look at their intent? Because opposing counsel's argument was that they were using it in a more colloquial sense. They weren't saying this man's committing a crime. They're saying this man's doing something shady.
So, Judge, I think it is absurd in its face to say that they are using the word black market that has but one definition in the English language in a way that it wasn't intended to be used. So what CNN is claiming is they took a word from the English language that has one definition, and they meant, when they said black market, they actually meant gray market. But they said black market that has one definition. CNN can't get up there and say, hey, Mr. Young is a serial killer, but actually mean that he was a good Samaritan, but they only knew that in their head. And you know what, Judge? If they did, fine. Let them argue that to the jury. At this stage, as the court was focusing on appropriately before, we need to show a reasonable showing that a reasonable basis for punitive damages exists. Will a jury buy that argument that they meant something else when they said black market? I don't think so. But this court is only serving in a gatekeeping function at this point to ensure that proper claims of punitive damages reach the jury. And to say that when somebody uses a word that means what it means is not a sufficient showing, then I don't know what should reach the jury for punitive damages claims. And, Judge, that's really important. You really need to focus on the standard that applies in this case, because there are three overarching standards that apply. The first is that plaintiffs have to make a reasonable showing of a reasonable basis, that a reasonable basis exists for a jury to find that CNN purposely or recklessly defamed Mr. Young. But that's not all. And I want to point out, not a perfect showing and not a perfect basis. Reasonable showing, reasonable basis.
So your argument is that sub 2 of 768.72, where it says that the trial fact based on clear and convincing evidence, that's not here.
Correct, and in fact, we
That-
filed a notice.
That's the jury's charge.
That's the jury's charge, and we filed a notice of supplemental authority yesterday with the court from a decision from the third DCA that came out in late March, which had that expressed finding, which is, at this point, clear and convincing evidence is not required. It's an express finding from the third DCA. So we just need to show the reasonable basis, reasonable showing a reasonable basis. Now, to win, we need to show clear and convincing evidence, but that's not what's before the court today.
But you would agree that it's not like a typical cause of action standard where we're required to accept your allegations as true for the purpose of the amendment, that reasonable showing by evidence means something more than that, I presume.
It does, Judge, and that folds into the two other standards that I said were overarching, right? So when you look at the proffer, right, it's not an allegation like on a motion to dismiss or just now. It needs to be evidence, and evidence was put forward. The fact is, we didn't need to wait for deposition testimony because the evidence in this case is overwhelming and put before the court. So when you look at whether a reasonable basis of a reasonable showing of a reasonable basis occurred, you must look at the case, you must look at the evidence presented, in the light most favorable to the plaintiff. And that's the 701 Palafox decision from this court, that the evidence is viewed in the light most favorable to Mr. Young. And when looking at the evidence, it's not viewed in isolation. You look at the totality of the circumstances.
So I was on Palafox. I don't, and I don't think we answered this question about the relationship between the reasonable showing and clear and convincing evidence. Do you think to resolve this case, we need to wade into that and answer that question here?
I don't think so, Judge.
So like the fourth certifies a question on that very issue, right? In Perlmutter, do you think that we need to go all the way there?
I don't think so, Judge, because I think the language of the statute is very clear that it needs to be a reasonable showing, reasonable basis. Even if the court were to fold in that has to be a reasonable basis of clear and convincing evidence that a jury could eventually find, that information is before the court right now. So even if we were being held to a clear and convincing standard, there's still sufficient evidence in the record to show that we've met that burden. And so I think the court can sidestep that issue entirely. In fact, there's a couple of issues CNN raises that I think the court doesn't need to resolve. Another issue is, does the court have to weigh competing evidence in this case? Doesn't matter. The court doesn't need to resolve that question here because even when taking all of CNN's evidence into account, when viewed in the light most favorable to Mr. Young, it is very clear here that Mr. Young has satisfied the burden imposed by the statute. So if I turn to some of that evidence, there are essentially three buckets of categories of evidence that were put before the trial court. One is that the facts that CNN knew, and those facts undermine any suggestion that Mr. Young was involved in any kind of illegal activity. The second category is CNN's internal documents. They demonstrate that CNN held significant bias, ill will, and an agenda against Mr. Young. And the third is CNN's reporting itself, which, as I'll demonstrate in a minute, was so reckless, shoddy, and agenda-driven that its own editors were in full revolt that CNN was publishing these stories. So going to the first category of illegality, number one.
I'm concerned about that because, I'm sure that there are editorial disagreements in news organizations all the time. And I'm wondering how much we should use those disagreements as evidence of malice or reckless disregard. Because I'm sure on a lot of stories there's internal debate. And there's someone that has to make the decision based on hearing everybody out, and I don't know if that's evidence of malice or ill will or any of that.
Well, Judge, I would suggest that the evidence in this particular case goes beyond mere disagreement. I'll highlight that in a minute. But again, that brings me back to the idea that is undisputed. This is a totality of the circumstances review. So it could be that the editor's comments standing on their own are insufficient to get us to malice. Mm-hmm. You've got to fold that into.
And can you try to stay central behind the mic?
I'm sorry.
Because this is being recorded.
I will hold on tight.
People are good. You can move some, but if you get too far away, they're not going to be able to hear.
Understood, Judge. I'm sorry. So this is totality of circumstances. So fold that into the terrible, statement CNN made that show that they're going to nail the Zachary Young MFer, that they are, that he's a shit, an a-hole, some of the other terrible statements, like it's your funeral, bucko. Fold that into the divergence from journalistic standards, taking from a clearly biased source and running with an agenda. Remember, my learned adversary here talked about a woman that Mr. Young called a, quote, spiteful bitch. Well, she was the source of this entire story. And at the end of that exchange, once the story was published, Mr. Marquardt sent the story to her and said, probably not as bad about Young as you had hoped, right? I mean, this was a clear agenda-driven story. So my answer to your question, Judge Roberts, is maybe on its own it's not enough, but look at the totality of the circumstances. Stepping back, on its own it's enough. This is not mere disagreement. The editors called it a, quote, infernal story that was, quote, pretty flawed and, quote, very much not ready
Well,
for
it certainly
prime.
sounds like all these people got off on the wrong foot, but, the fact that there was a level of contention and there were unfortunate things said on both sides. How much of that can we use to say that CNN didn't follow their journalistic duty?
Well, those are two separate questions. The nasty emails from CNN go to showing that they intended to harm Mr. Young. And I don't see how you can come to any other conclusion from the statement, we're going to nail that Zachary Young MFer. What a punchable face. It's your funeral, bucko. When he said, I'm going to nail this Zachary Young MFer, the response was, going to hold you to that, cowboy. What a shitbag. What an asshole. He's a shit. Triad. One of the members of Triad, CNN's senior executive committee, said, yeah, he's a shit. So this doesn't go to their diversion from journalistic practices. It goes to malice. They wanted to harm him. They wanted to hurt him with this story. What goes to the diversion of journalistic standards is the rush to publication. They gave Mr. Young 2 hours. Yes, they talked to him for a week, never telling him they were going to publish a story about him. The first time they say, we're publishing a story about you, they give him 2 hours to comment. Mr. Young says, you're wrong, and that's not enough time for me to comment. And what's CNN's response? Mr. Marquardt texts a colleague, effing Young just texted. But even though he says effing Young just texted, he doesn't delay
So
publication.
do we know in the record when Mr. Young became aware that he was talking to CNN?
He knew he was talking to CNN earlier, but they were told him they were trying to gather information about like the evacuations in general. They didn't tell him they're running a story on
Well,
him.
CNN is in the business of running stories. Why does he think that he just called him because they think he's a good guy or wanted to get to know him?
Well, CNN does background research all the time. If you go into the discovery, even the evidence in this case, CNN talked to many people they didn't end up quoting. In fact, while they spoke to many different people, Mr. Young is the only person in the entire story that is mentioned and whose face is on the television and his name is on television with the accusation of black markets right underneath it. So I think, Judge Roberts, in fairness, just because CNN reaches out for information doesn't mean they're running a story about you. And the moment they tell you they're running a story about you, they give him 2 hours to comment. He says it's not enough time. And by the way, CNN's own internal people thought that wasn't enough time. There's this internal correspondence in the record. I hear it's airing tomorrow. Seems early. Answer, airing in 2 hours. Response, well, shit. So CNN itself knew 2 hours was not insufficient amount of time to let the story run.
Well,
And so,
one employee of CNN thought that was insufficient.
fair enough, Judge, but again, reasonable showing of a reasonable basis that there was malice, departure from journalistic standards. This court isn't supposed to be the ultimate trier of fact on whether or not CNN is subject to punitive damages. That's the jury's province. This court is supposed to act in a gatekeeping function to make sure meritorious claims meet the jury and to winnow out the bad claims. This is not a bad claim, right? CNN has no evidence that they thought Mr. Young was engaged in illegal activity. There's significant evidence that he was not engaged in illegal activity. There is proffered evidence to the trial court that CNN was trying to harm Young and hated him. There was evidence proffered that the work on the case was so shoddy and agenda-driven that many of the internal editors were uncomfortable with the story going forward. There was proffered evidence that CNN departed from basic journalistic standards, rushed to publish, ignored warnings from Mr. Young, relied on a biased source. How can it be that this isn't a reasonable showing of a reasonable basis to find that malice occurred here, and that CNN, at a minimum, recklessly published the story. And if this court finds that this isn't enough, I don't know what case is. Is the court requiring a private journal from Mr. Marker where he says, I really hate this guy, Mr. Young, and I think I'm going to write a story for the sole purpose of harming him? I mean, there's plenty of case law we cited to the court that says people don't advertise their defamations in advance. You're almost never going to find that smoking gun admission of internal intent. What we have to do is show a basis that the jury can say, you know what, this is malice, this is recklessness, this is purposeful attempt to harm. And we've shown that. Through all the evidence that's come through, we've proffered sufficient evidence to make a reasonable showing that there was a reasonable basis for a jury to find. CNN, at a minimum, recklessly published this material. The only other thing I want to touch on is this idea of that black markets subjectively meant something else. Again, we touched on this, but CNN cites a bunch of authorities for the proposition that, that's not enough. And the way I want to push back on that is if you take a look at these authorities, all of those authorities were statements where the alleged defamatory statement was ambiguous or was defamatory by omission. And there's a huge distinction between those where you have an ambiguous, like a metaphor, where the sound is wandering around the room, and so you need more, and our case where they use the term black market that has, again, but a single dictionary definition in the English language. Unless the court has questions, I see I'm over my time.
Thank you.
Thank you, Your Honor.
May it please the Court. Your Honor, Judge Long, to your question about the clear and convincing evidence standard, it's not been adopted in the first DCA as binding on this question, motion for leave to amend. It has been adopted in Federal Insurance Company versus Perlmutter in the fourth DCA. In this instance, it is required, regardless of the statutory construction, for actual malice, because actual malice must be shown in any inquiry by clear and convincing evidence. We get that from New York Times v. Sullivan. We get that from Mile Marker versus Peterson Publishing Company in the fourth DCA and the Don King's production case in the fourth DCA. So to make a reasonable showing to a jury, he had to have proffered sufficient evidence to meet the clear and convincing standard of actual malice. I think it's an open question, to be honest, about the express malice and the outrage part of the calculus, but as to actual malice, that is required, that is his burden. And as to the word black market, there is nothing in the record discussing what CNN was thinking, what they were saying to each other, what their intent was. There is an absence of any evidence in the record, and because it's such a high burden, because it is his burden, such a high standard, it can't be assumed, it can't be applied, it has to be shown by record evidence, and plaintiff simply has shown none whatsoever. As far as the words exchanged among the journalists themselves to describe Mr. Young, we talked about that. I just wanted to point to the court language in Nodar versus Galbraith from the Florida Supreme Court that specifically says strong, angry, or intemperate words do not alone show express malice. And so I think there's a recognition in the courts that if people express themselves in certain ways about the plaintiff, there are no inferences to be drawn if that's the evidence that they're pointing to, and they rely very, very heavily on that.
Well, does that mean there's no inferences, that you can't draw a reasonable inference, or does that just mean that it's maybe not enough alone?
If the email said, I know this guy, I've been watching him for years, we're friends, he didn't pick my daughter up at daycare on time, he's a shitbag, I'm going to run a story on CNN and get him. That would be great evidence of express malice, of a primary motive or intent to harm, which is the standard, primary motive, not secondary, not tertiary, primary motive. That's not what we have here. We have, as I recited before to Judge Roberts' question, we have a series of information, pieces of information coming into CNN from which they were reacting and forming an impression, and that's the opposite of actual malice. That's conviction, clear conviction in the gist of that portion of the story that Mr. Young was a profiteer. Your Honors, Your Honor, you brought up, or he brought up and you reacted on the Palafox case. I think the Palafox case is an excellent illustration of what you do with plaintiff's evidence. You look at it, you accept, or you read what he proffers to you. In the Palafox case, it was the engineering report. that talked about one type of equipment, one type of property, and then you look at the other evidence that's put into the record. And in Palafox, they looked at the two different sets of issues, the engineering report and the equipment was used elsewhere for a different purpose. And you held correctly that that was not evidence, that report was not evidence of the high standard needed for punitive damages. And we are talking about a very high standard here. It must be so outrageous that society can't tolerate it. Yesterday, he cited to the court a drunk driving case, which the Florida Supreme Court has said per se is intolerable for good and valid reason. But it also notes and reinforces that it has to be as high as a standard of criminal manslaughter, the conduct. And the journalism that CNN published in the public interest to talk about war profiteering in Afghanistan during the time period when many people thought that the U.S. government had precipitated a chaotic and dangerous environment is not committing criminal manslaughter, is reporting journalism in the public interest and should not be subject to punitive damages. Thank you, Your Honor.
Counsel, I thank you both for your argument. It was very enlightening and well crafted. We're going to take a 10-minute recess to allow counsels to shift. We are in recess.
All rise.
versus the State of Florida. It's 22-3664. Counsel, if you're ready, you may proceed.
Thank you, Your Honor. May it please the court, opposing counsel. The appellate would like to reserve 5 minutes for rebuttal. As this court is aware, the appellate is here seeking a remand in this matter for an evidentiary hearing to determine whether he's entitled to a new trial based on newly discovered evidence. That newly discovered evidence is the recanted testimony of the only identifying witness in the case. We're also seeking a remand based upon the prosecutorial misconduct of the statements where she rehabilitated the erratic testimony of that witness. And third, we're seeking a remand with instructions to exclude all the improper and illegally obtained wire recordings of a phone conversation, especially those that were not of a criminal act. As this court is aware, Mr. Goldsmith was charged with dealing with a controlled substance. He was charged with selling one transaction of $160. That transaction does not fit under the definition of the 934-03 because it does not include an organized crime. You have to get under an organized crime before you can get into the balance of the statute and try to find the exceptions. So specifically, we'll address the question whether we should get a rehearing for the newly discovered evidence. And in that newly discovered evidence, the opposing counsel, the state, has said that we're not entitled to that because the affidavit presented to the court was not evidentiary evidence to be able to use before the court. In the amended motion for new trial that was filed, there was an affidavit submitted by a witness that said...
Was that an affidavit?
Sir?
Was that an affidavit? I didn't see any kind of jurat that shows
It was-
that it was sworn. I saw a notary seal, which says that it was the
And
person
you may be
who it
correct.
purported to be, but it wasn't a sworn affidavit.
You may be correct. I believe the witness swore that she heard the statement to the statement of that witness, but the person himself did not swear to it. You're correct. So
Okay,
that statement...
So there was a hearing on the second motion for new trial.
Yes, sir, there was.
So wasn't that your opportunity to demonstrate that you were entitled to new trial?
Well, there's two phases to that. The first phase is that you file the motion to see if the court will grant the evidentiary hearing based on the written documents before the court. The written documents before the court said that a statement was made by the witness that recanted her trial testimony. The responsibility of the court then is to say, well, based on that statement, if it's true, then we need to consider whether that's enough evidence to grant a new trial. And they should have scheduled an evidentiary hearing, had the opportunity to subpoena witnesses, had an opportunity to bring any other additional evidence that might be there to show why the recanting testimony was new, especially...
I'm sorry, I'm confused because I thought that actually, I'm unaware of this preliminary hearing to show whether we should have a hearing. That sounds like what we do in post-conviction motions. I've never seen it done for new trial. Is there any case or rule or statute that says that that's the way that we handle motions for new trial?
Yes, sir, Your Honor. In the Guzman case, they specifically said that they first consider the written documents that are there before the court. And once you've considered those written documents, if those are enough to grant the evidentiary hearing, you grant the evidentiary hearing. And in this case...
Guzman's a capital case, isn't it?
Sir, no, sir.
Okay.
This is a $160 transaction of a drug transaction. That's all. Was Guzman a capital? I don't believe it was, Your Honor. I can look.
Because that sounds like there was what they call a Huff hearing in capital cases to determine whether they should have an evidentiary hearing. Never seen that in a non-capital case, and I've certainly never seen it in a new trial context.
The statute, the 3850, the rule seems to provide that you have to file the motion first, and based on those written documents, then the court moves to an evidentiary hearing. If you do it otherwise, you would put the burden on either one party or the other, surprising the opposing counsel when you got to that hearing and say, well, I've got witnesses to present. The other side would have no idea that witnesses are going to be presented. And that would be a violation of due process for the defendant or a violation on behalf of the state. The state would not be prepared to do that. In this instant, what the court did is said, well, there's somebody in the sitting out in the courtroom. Let's bring them in to testify without notice, without an opportunity to bring opposing witnesses. So we're going to do that. And for that reason, the trial counsel objected to that process because it didn't seem to be proper, because there wasn't an opportunity for them to have brought their witnesses to the hearing. The first question is, can you get past the gate? Does the evidence that you're suggesting that you found raise to the level of enough to make a question whether that's going to grant a new trial? Once you look at the written filings, then you turn and go to open the gate, let's have an evidentiary hearing. If the evidence doesn't support the reason for a new trial, and you're weighing whether or not it's going to overturn that conviction, in this instance, we believe it would, because you've got the testimony, the only witness that saw him, the only witness that said the transaction took place, the only witness that said that he's the one that said he was going to sell me something and where we're going to meet. That witness, that is the only witness, made a statement that said, I lied. She also said that not only did I lie, but because the state was prosecuting me in another case, I was doing things to keep out of going to jail for another case.
I have a concern about the propriety of the second motion, but before I get to that, didn't the trial judge actually make a credibility determination in ruling on the second motion for new trial? And if so, how are we supposed to challenge the trial judge's credibility determination?
Well, he made a determination of credibility on a witness who was not in front of him. And as you pointed out, this was not an affidavit that was attached, so it was based off of a statement. He made a determination that I've not seen the person, I've not talked to the person, I've not looked at the person, but I'm determined that they are not reliable. So I'm not going to consider that testimony.
So isn't that often what's done in what I'll call the Huff hearing and in the preliminary hearings before post-conviction motions, is they determine whether the evidence presented by the defendant is credible enough to support a evidentiary hearing?
Well, in this instance, there was no opposing written documents. The state did not submit anything written to the court that said this is a false statement. In fact, the court, the opposing or the state conceded at that hearing that, hey, this took place after the jury trial when we were here on another matter. They met each other out in the court anteroom and had some discussion. So the state knew this took place after the trial. So, the question is, do we believe her or do we don't believe her? But the real question is, does it affect the credibility of the state's identifying witness? And so without taking her testimony to determine whether her statements are true, I don't know how you can rely upon her reliability or not.
All right, I understand. So let me go back to my first question, which is, my understanding is that the 10-day period for new trial it's been called jurisdictional. Don't necessarily prefer that, but I've also seen it called inflexible. You have 10 days after the jury verdict to move for new trial. If you have, and in this case, this isn't something that happened at trial. This is new evidence that was discovered after trial, that the typical place that you raise such a claim is in post-conviction rather than new trial, which has to be filed in 10 days, and this wasn't. What difference does that make?
Well, there is the 10-day motion was filed for the new trial under prosecutorial misconduct. The other motion was originally filed without oath, and then the defendant was sworn to under it, making it a 3850 motion that could be filed.
Isn't this premature
After.
for a 3850 motion?
Sir?
This is premature for a 3850 motion. There hasn't even been judgment, much less an appeal.
No, it already been a conviction at that time. This is after the
It
jury
wasn't-
trial.
I mean, but it wasn't, go ahead.
I mean, I'm sorry if I don't understand that timing on that, but from what I've read, it was appropriate to be filed anytime after the conviction, as opposed to even after the appeal. So, but primarily, we think that there's a problem with that. The statute that the state misapplied, and that statute was the point and purpose of the motion in limine that was filed in the case. And the motion in limine was asking to exclude the testimony of the, all the evidence that was obtained by the
Mr.
phone
Moore,
conversation.
you may certainly proceed, but you're getting into your rebuttal.
Yes, sir, I see that.
Yeah.
I just want to touch base, then
Sure.
I'll reserve the balance, Your Honor. The recording of the statute says it's got to be a criminal act, and it's got to be a organized crime, and we can't find that the evidence of one transaction qualifies as an organized crime. The Atkins court has restricted the application of that statute to the evidence of the criminal act itself. And recording a phone conversation between the parent and the child doesn't seem to be a criminal act. The element that he was charged with was sale, and sale does not have anything to do with what the parents are talking about raising their child. I'd like to reserve the balance of my time. Thank you, Your Honor.
Please the court, Adam Wilson on behalf of the state. We're asking that you affirm the judgment and sentence here and affirm the denial of the motion for new trial or the 3850, whatever it was. As an initial point, I think it's important to point out this court's decision in Rogier, where you held that issues raised for the first, that are not raised in the initial brief are considered abandoned. And so this whole argument about we didn't have notice, or this was really supposed to be the preliminary evidentiary hearing, and that we needed a second evidentiary hearing. None of that appears in the initial brief, and it was never actually raised in the lower court. It appears for the first time in the reply brief. So we would consider that to have been abandoned or waived. But even if it isn't abandoned or waived, I don't think there is a requirement to have a second evidentiary hearing. There's nothing in Rule 3850, or I've never seen any case law that suggests that there are two hearings in a post-conviction, a non-capital post-conviction case. Certainly the Guzman case that he cited, I don't think says that. In that case, there was a sort of preliminary hearing, and then there was no actual evidentiary hearing, and that was why it was reversed. But the court never spoke on saying that there is a requirement that you have two of these hearings. And so in this case, the actual issue before this court as to the motion for new trial is whether he was entitled to a new trial based on the evidence that he presented at that hearing. And when a defendant moves for a new trial on the basis of newly discovered evidence, he bears the burden of showing that the evidence is newly discovered and that it would have probably produced an acquittal on retrial. And if you don't produce any evidence, I don't see how you can meet that burden. And again, if you look at the record of that hearing, the defendant at no point suggests that, hey, we're moving too fast, this is only supposed to be preliminary. He seems to be acting under the impression that I have a piece of paper, which Your Honor correctly pointed out isn't an affidavit, isn't sworn, I get a new trial. He wanted a new trial. If you look at the initial brief, it was also asking this court, please remand for a new trial, not remand for an evidentiary hearing. Given that the defendant never introduced any evidence, I don't see how he could have established his burden of establishing newly discovered evidence that would probably produce a acquittal on retrial. As to the third issue, the recordings, again, This argument about organized crime, I've never heard that. That wasn't even in the reply brief. That's appearing for the first time today. I don't know where that's from. There is no requirement that law enforcement be investigating organized crime before they have an informant wear a wire. The law is pretty clear, Section 934, that law enforcement or a person authorized by law enforcement can wear a wire to a drug sting if one of the parties to the conversation consents to the recording and it's for the purpose of gathering evidence of a crime. I submit to you that wearing a wire to a drug sting is obviously for the purpose of gathering evidence of a crime, even if it happens to include some conversations that do not strictly involve the actual hand-to-hand transaction between a drug dealer and a drug buyer. As to the second issue, the prosecutorial misconduct during closing argument, that was raised in the motion for new trial. That doesn't preserve it, so it has to be fundamental error. I submit to you that there was no misconduct whatsoever. The commented issue, I think, is when the prosecutor was reciting facts about how many drug buys the CI was involved in, and that's perfect. That's pretty much the point of closing argument, to recite evidence introduced at a trial. And even if it was slightly improper, it was an invited response to the defendant's closing argument, which focused heavily on the CI's credibility and the fact that she was lying, which is also an inference drawn from the facts. It's certainly not fundamental error. And if the honors have no more questions, the state asks that you please affirm. Thank you.
May it please the court. The issue of the objection to Lieutenant Maddox testifying was raised in the brief on page 16. He said he testified over objection to the defense counsel. And at that point, the judge also at that point in the time said there was an objection raised to his testimony, and the court said, I'm going to overrule your objection. We're going to go forward with the testimony. And this was not on notice that this person was even going to be appropriate to the court. So there was issues raised. They were raised in the brief. They were raised at the trial court. There were objections raised all through this, and specifically on the issue of the 934-03 exception, there were numerous objections raised as completeness, because there were recordings that were piece and part and piecemeal of recordings. Contrary to what the state said, the whole recording was not played to the jury. Only portions of the recording was played to the jury. The witness testified that one portion of it was a recorded text message, and yet her voice is on that recorded text message. That loops back around to the question of trying to rehabilitate this witness and saying she's testifying honestly to everything that's here before you. She was at the start of it. She turned left on second. That's all I know. Then there's the defendant testifying, change in me. I would never harm my son, etc. There's something from the confidential informant. The recording stopped. She's asked, what is that? He sent me a voice recording through text. Well, her voice is on that. There's no understanding of whose phone was used to make that recording, whether it was the police officer's phone or whether it was her phone. We don't believe it was the police officer's phone because the transaction had been completed, if it's according to her, later in the day, and therefore she recorded it solely on her own phone. She was not under direction of a police officer at that time, and that is strictly invasion of privacy. The state concedes that the only reason to record anything beyond the sale, exchange, the portions that are criminal act, is to identify the defendant. Well, that's not authorized under that statute. Under that exception, The 934 statute is extremely restricted, extremely limited, because the legislature said this is an exception to what we want to allow. And if you go farther into it, there's many things requiring warrants for most all of those. And I really believe that exception they have is for times of emergencies, when there's terrorism, life damage, property damage type things that would raise to the level of major crimes, which is what the other restrictive language at the start of the 934, the 934-01 is. It needs to be an organized crime, and it needs to be a major crime. And we would suggest that the $160 transaction, single transaction with the defendant, is not organized.
Was this argument made in your brief?
Yes, sir, it is in the brief. So it's not major, nor is it an organized crime. And for those reasons, we would ask this to be remanded. And if there's no further questions, I'm out of time. Thank you much for your time, Your Honor.
Counsel, thank you for your argument. We have no other cases before us, so we are adjourned.
All rise.